The following program is suitable for general audience of any age.
Tonight, we discuss the fundamentals of law surrounding the right to a fair trial in criminal cases, how the rights of the accused balanced with the need for justice. A very good evening. You're joining us on Law, Land and Liberty here on Other Derana News Channel, where we bring to you key legal concepts and break it down for the layman. Tonight's topic is something that we have previously touched on in passing but have not been able to get into when it comes to the in-depth conversation relating to it, and that's on a right to a fair trial in criminal procedure context. Specifically, we've had recent programs as well that focuses on the criminal law context, especially when it comes to the victims and also the accused, and how exactly the law plays about in Sri Lanka's context. Today we're going to be talking about specifically the right to a fair trial and what exactly the law is when it comes to the enshrinement of it, and the current context that we see when it comes to the layman wanting to understand exactly what this right to a fair trial actually means in a criminal law context. And to speak about this, we have someone that is not a new face on the show. We have had him previously as well to speak about a very complicated topic, and he's back again with us. I'm very pleased to invite back onto the program Mr. Darshana Kuruppu, attorney at law. So thank you so much for coming back.
Thank you for having me, Anuradi.
A little bit of an introduction, Mr. Kuruppu. I feel like if you would have watched one of our previous programs featuring him, he is a defense attorney with over 18 years of experience at the bar, and specifically he was also the individual most noted for calling DNA evidence in court in Sri Lanka for the first time ever. So safe to say we have a lot of expertise and understanding when it comes to the progression of criminal trials and proceedings, especially in Sri Lanka's context, and how exactly to go about it. So to approach this topic, first we'll be getting into the fundamentals relating to what a right to a fair trial in a criminal context means. Next we'll be getting into the current context, specifically relating to recent updates as well, and what we can see moving forward as reforms, amendments, and what the future holds for Sri Lanka's legal landscape in the criminal law context.
Hi, I'm Sajini. I'm an LLB graduate, and my question is on fundamentals. Which legislature governs the right to a fair trial?
All right, well, without any further ado, let's get right into this discussion. Thank you once again, sir. I understand that this is a very vast subject area, so we can try and cover as much ground as possible. But before we get into any of the specifics, I feel like it's important for the laymen that are watching to understand what exactly counts as a fair trial. What is the right to a fair trial? Can you help us understand the concept behind it first and foremost?
Yes, Anuradi, actually, right to a fair trial is timely and deeply important topic. Before we discuss about this topic, let me share a story with you. In 2005, a 20-year-old university student in Mumbai was found dead in her hostel room, and the university authorities alerted the police, and police came to the place, and it was found that she had been brutally raped and murdered. So the JMO was called. JMO, Judicial Medical Officer, conducted the autopsy, and he also found that the girl had been brutally raped and thereafter stabbed to death. There were multiple stab injuries to her chest, and police began the investigation into her death and recorded statements from various people, including her colleagues. And it was revealed that she has been in a relationship with a banker, 25 years old Rajan, and police straight away went to the house of Rajan and they took Rajan into their custody. And police detained Rajan for several days and brutally assaulted and obtained a confession that Rajan is the one who raped and murdered his girlfriend. So this news about the death of the girl and arrest of Rajan went viral on all the media platforms, including social media platforms. Due to the shame, Rajan's father, who was a principal, took his own life, committed suicide, and the police subsequently produced Rajan to the magistrate. Magistrate ordered Rajan to be kept in remand custody. Rajan at the police station insisted that he did not commit this crime. He has no whatsoever involvement to this offence. He was not in Mumbai, but he was in Delhi, almost 1,400 kilometers away. He had a very strong and believable alibi, but police didn't believe his story. So what happened, while Rajan was in remand custody, he also died due to the injuries inflicted by the police. At the time, JMO examined the dead body of the victim. JMO collected semen from the victim's body. Semen was sent to the lab for a DNA analysis, and the police arrested the Rajan, and his DNA also sent to the lab. So after the death of Rajan, DNA report came, and it was revealed semen found from the dead body of the victim does not match to the DNA of Rajan. So it is very clear victim didn't get the justice, and Rajan didn't get the justice. Anuradhi, family members of the victim have an absolute right to demand for justice. Not only family members of the victim, even family members of Rajan, they also have an absolute right. Even Rajan is having an absolute right to demand for justice. But what happened? Rajan died inside the prison, and this poor girl was brutally raped and murdered. And what happened? Rajan's father took his own life, and it was revealed from the DNA analysis Rajan is not the perpetrator. That means, Anuradhi, real perpetrator is still at large in the society, perhaps free to commit rape and murder of innocent girls. So this is a classic example that if you don't protect the right to a fair trial, the system fails, and because a crime is considered as an offence against the society, so the victim, suspect, and the society is entitled to seek justice. So as far as the right to a fair trial is concerned, there is no detailed and specific definition, but as far as our constitution, that is the basic and fundamental law of Sri Lanka, Article 13(3) of the Constitution, which says that every person must be heard, every person who is charged for an offence is entitled to right to a fair trial, must be heard at a fair trial by a competent court. When it comes to the international context, Anuradhi, Article 10 of the Universal Declaration of Human Rights and Article 14 of the International Covenant on Civil and Political Rights also ensures the importance of the protection, the right to a fair trial. So this is a very, this is a fundamental right and very, very important right as far as the victim of a crime, suspect of a crime, and society is concerned.
Exactly. That's an important point I wanted to ask you as well, relating to now when it comes to the international context as well. So we do have to get into the specifics maybe later on in the program. But before that, for Sri Lanka's legal context, as you mentioned, I was able to pick up on the fact that there is no specific law that enshrines a right rather than the fundamental rights that are already being granted to citizens of Sri Lanka. Can you tell us if there are any other laws surrounding which that actually help us ensure that a fair trial is guaranteed to an accused?
Yes,
are there other laws?
Not only Article 13(3) of the Constitution, even if you take the Criminal Procedure Code, there are several provisions which protect the right to a fair trial, and there are several other acts and ordinances which protect the right to a fair trial. So our law, not only the legislation, but as far as the judicial decision given by the apex courts in Sri Lanka, have identified this as a fundamental right of a citizen. So right to a fair trial is protected in every civilized society. So I would say it's a fundamental right that every citizen is entitled.
Exactly, a fundamental right. And I want to get specifics into that fundamental right as well, sir. As you mentioned, the components that comprise of ensuring a fair trial, a fair criminal trial in this sense, as you mentioned now specifically when it comes to evidence as well. Now in the story that you mentioned previously, had there been a collection of evidence much more sooner, there could have been a completely different output to that story. And also there's that conversation relating to the presumption of innocence and then the access to counsel as well. So can you please walk us through these components that help us comprise of the right to a fair trial and ensuring that the accused gets the proper representation they deserve?
Yes, Anuradha. Certainly. Now, as far as this right is concerned, there are several principal elements of this right. Especially the Supreme Court of Sri Lanka in 2008, in the case of Attorney General versus Segulebbe Latif, Supreme Court held that there are 12 fundamental principles that needs to be protected. Especially, first is that everyone is equal before the law. Whether you are rich, whether you are poor, whether you are black, whether you are white, everyone is equal before the law. You know, Anuradhi, we say that it doesn't matter how tall you are, the law is above you. So everybody is equal before law. So the equal treatment must be ensured, and fair and public hearing. As you mean now, if you are suspected for committing crime, so the government cannot have an isolation courthouse to try you. You should be tried before a competent and independent and impartial court or tribunal by an impartial judge. It's a fundamental right, public hearing. Everybody who is suspected of committing a crime, whether you are charged before magistrate court or whether you are indicted before high court, you have a right to be heard before a competent court or tribunal by an impartial judge. Public hearing is a fundamental principle of right to a fair trial. And also presumption of innocence, as you correctly said, according to our constitution, anyone who is charged with an offence is presumed to be innocent until and unless the prosecution proves its case beyond reasonable doubt. If you are an accused before a court of law, you have no burden whatsoever to prove you are innocent. It is the prosecution duty to prove all the ingredients of the offence concerned. But there are some exceptions. If you take a special defense of alibi or defense of insanity, so burden lies on you. But if you are accused of committing crime, it is always burden is on the prosecution to prove the case beyond reasonable doubt. And in order to prove that, prosecution should call witnesses, and also you should be informed what is the charge against you or what are the charges against you in a language that you can understand. Assuming you are a Tamil person, your mother tongue is Tamil. So if the court proceedings are conducted in Sinhala, so you are entitled to have a translator or interpreter, because you will not be able to understand the proceedings if you are not provided with a translator. So assuming you cannot afford a lawyer because of poverty. So if you are indicted before high court, the court or the state will assign a counsel for you. So you have a right to have pre-legal aid. And also the courts, when it comes to a criminal case, whether it is in the magistrate court or whether it is in the high court, the judge has to explain you what are the charges against you and your rights. And you have a right to cross-examine witnesses who come to give evidence against you. And also you have a right to remain silent, because it's a right of an accused. Accused can remain silent because it is always prosecution should prove the case beyond reasonable doubt. And also accused can give evidence, call witnesses on his behalf, and court will always consider the evidence of the accused and the witnesses call on behalf of the accused also before arriving at a decision. So there are several fundamental rights. So and also no person who is accused of a crime can compel to give evidence against him. So you can't be compelled to give evidence against you, because that is why we say that right to remain silent also is a very important right when it comes to a criminal case. So there are several fundamental elements of a right to a fair trial. I have observed, I'm still observing that our courts across the country always make sure that these rights are safeguarded and protected. So as far as our justice system is concerned, our justice system is always trying to balance the rights of the accused and the victim and the state, and always make sure, our courts always make sure that accused person will get a right to a fair trial.
Exactly. That is the most important point, the balancing of the rights that are awarded to each side of the argument, specifically relating to the fairness of a trial in its sense, as you mentioned in your previous conversation also, about how now the actions of multiple actors, stakeholders, when it comes to the police, when it comes to the judicial process, and maybe handling officers, the medical officers, it all depends upon the fairness of the trial. Can you tell us just how drastically that the fairness of a trial can actually be impacted by maybe police delays, courts delays, practical obstacles of that nature, especially when it comes to the investigative delays as well?
Yes, this is a very important question. Anuradha, now what happens in Sri Lanka as a criminal lawyer, I have experienced in almost every case, the police, they have to commence the investigation when a complaint is received, or if somebody complains about a crime, the police will start or begin the investigation. So police should make sure that they will have a speedy investigation and fair investigation. So if they don't conduct the investigation correctly, so they will not be able to collect evidence, especially when it comes to the scientific evidence. I have seen in many rape cases, this, when the victims complain to the police will not make sure that the samples of semen will be collected at the earliest possible opportunity. So if they collect samples, the scientific evidence will be destroyed. So it is very important to have a proper investigation. That is the very foundation of a fair trial. Proper investigation, it should be fair to the victim as well as the suspect. Now, as far as the early example is concerned, that was not a proper investigation and fair investigation, and entire investigation collapses. So neither suspect nor the victim receive the justice in that example, as far as that example is concerned. So police should make sure that they will have a proper investigation. They will have to make sure that they will get the support or the assistance of the expert witnesses like JMO, like DNA specialist and scientific or digital evidence, and then they will, without delay, now you know, justice delayed is justice denied. And also in the meantime, we'll have to understand justice hurried is justice buried. We should not rush. But I have all eyes, as a defense lawyer, I have seen many cases where the police or the investigating agencies had rushed to the judgments. And they have arrested the suspect, and then thereafter, in order to implicate that suspect, they collect evidence or they fabricate evidence. That is why in most of criminal cases, accused get acquitted. At the end of the trial, the court cannot convict due to the lack of evidence, or the prosecution cannot prove the case beyond reasonable doubt because there was no proper investigation into the crime. So it is the police should make sure that there will be a proper investigation. Then police can always seek necessary orders from the magistrate in terms of the Criminal Procedure Code Act. So the magistrate will make necessary orders, especially to obtain telephone tower details, obtain expert reports. So the magistrate will always assist the police by making necessary orders in order to continue the criminal investigation. And then the police will have to produce the suspect in a reasonable time. And they should conclude the investigation within a very reasonable time. I actually saw few days ago Indian Supreme Court caused an investigation because the police or the investigation authority has failed to conclude the investigation within a very reasonable time period. So everybody, even the police, even the Attorney General Department, lawyers, everyone, as far as every stakeholder is concerned, all of us have a duty to assist this process in order to have a fair trial or justice to the victim, accused, and to the society.
Exactly. I want to get into the specifics relating to the rights that a suspect is awarded during police investigations as well, and also relating to the admissibility of obtained evidences by police or other forces when it comes to the admission of evidence and their acceptability as well in court as actual pieces of evidence, and also about the international context a little bit relating to the humanitarian aspect of it, as you touched on it previously as well, sir. But before we get into any of those specifics, we do have to go in for a short commercial break. You're watching Law, Land and Liberty on Other Than a News channel. We'll be right back after this. Stay tuned.
Hello, my name is Menakari Jayasinghe. I'm a student from Sri Lanka Law College. So my question is on the current context. What are the recent updates to this legal field? Thank you.
Welcome back to Law, Land and Liberty on Other Than a News channel. We're in conversation with Attorney at Law Darshana Kuruppu. So thank you so much for the previous segment. We were just getting done discussing the fundamentals relating to the right to a fair trial in criminal proceeding contexts. Now, there was an important point that we left off on previously before the break, that is relating to the rights that are awarded to each side, each party when it comes to these kinds of proceedings and trials. Specifically, if we can start off on the suspects end, especially when it comes to police investigations. There is a lack of understanding into what rights are actually awarded to a suspect during police investigations specifically. Can you please walk us through those, the rights?
Yes, Anuradhi. Now, assuming I will make a complaint against you, so there is a complaint against you, or the police, if there is a credible information that you have committed a crime, the police can commence investigation. But in order to arrest, assuming I am going to the police station now and make a complaint against you, the police can't come and arrest you without doing a further investigation to ascertain whether there is a reasonable suspicion that you have committed the crime. So unless there is a credible information or reasonable suspicion, police cannot arrest a person. So just because someone makes a complaint against another person, or there is a complaint, so the police can't come and arrest you. The police should investigate and clarify whether the complaint is correct or true. And if there is credible information, or if they feel that there is a reasonable suspicion that you have committed this crime, they can arrest you, and before arrest, they should inform you the reasons as to why you are arrested or the nature of the allegations against you. So every suspect has a right to know the allegations against him or her if the police is coming to arrest him or her. So that's a fundamental right which had been secured or protected by the Code of Criminal Procedure Act. And also, if you are arrested by the police, police should inform in writing the reasons to your family members. You are being arrested due to these reasons. And if you are arrested, the police should interrogate without detaining you for several days. So the law doesn't permit police to detain you at the police station more than 24 hours. There are some exceptions. So they should interrogate you, record your statement, and from your statement, if it is revealed that there is no offense, the police should release you immediately. And if there is evidence against you, police should produce you to the magistrate court by way of a B report or by way of a further report. And also, police should treat you humanly. I have seen there are several incidents where the police have brutally assaulted the suspects in order to extract a confession. Most of those cases where the suspects have made confessions admitting guilt for an offense that they have never committed. So that is a very unfortunate situation, because now we live in a digital era. So in order to have a proper investigation, the police should not assault a suspect. Instead of assaulting a suspect and instead of extracting a confession, they can use this new technology to continue the investigation to ascertain whether there is evidence against the suspect that he has committed the offense. So the police will always make sure that you will be treated as a human being, and your rights will be protected. Even in their custody, they will have to make sure that your protection is safeguarded. It is very unfortunate in Sri Lanka. Over and over, the Supreme Court has decided violation of fundamental rights of the citizens at the police custody. Even there are several custodial deaths had been reported over the past few decades, but still there is no stop to this unfortunate police custodial death. So the suspect has many rights even at the investigation stage.
Exactly. It's a very important point that you mentioned as well, that there is a continuance of occurrences that we see when it comes to custodial deaths as well, despite there being multiple stances put out by the Supreme Court in itself when it comes to judgments relating to it. I want to get specifics into something along that line, sir, which is relating to forced confessions. Now, we mentioned very briefly, touched on that point a little bit. Specifically in Sri Lanka's context, we've had this communication come up multiple times in the past as well. Can you tell us exactly how Sri Lanka's laws deal with such an implication of a coerced statement or confessions? Because I feel like that is one of the more burning issues when it comes to the rights that a suspect is handed in Sri Lanka's context.
Yes, Anuradhi. As far as the evidence ordinance is concerned, there are provisions which says that confession made to a police officer is not admissible. The exception is if you are arrested under the Prevention of Terrorism Act, temporary act, the confession made to an officer above ASP is admissible provided that the accused, it's the burden of the prosecution to prove that the confession is voluntarily made. So there will be a voir dire inquiry to ascertain whether the confession of the accused person is voluntary or not. So it is the burden of the prosecution to prove that accused voluntarily made this confession and there was no pressure or accused was not tortured or intimidated to obtain the confession. So, as far as the confession obtained illegally, it is inadmissible. So, anyway, as I earlier said, confession made to a police officer is inadmissible.
Exactly.
But the exception is, if you are arrested under the Prevention of Terrorism Act, and if you make a confession to a ASP or above, that confession is admissible provided that you have made it voluntarily without any force or any pressure. So, it is the burden of the prosecution to prove that confession is voluntary. But as you said that there are very black mark as far as these confessions are concerned. The classic example is Nalla Ratnam Singarasa case, where Nalla Ratnam Singarasa was arrested and he was convicted under the Prevention of Terrorism Act based on his confession, and he insisted that he did not make a confession admitting guilt. Unfortunately, the court convicted him based on the confession. So, after he appealed to the Supreme Court also dismissed his appeal. Then he went before UN Human Rights Committee, and UN Human Rights Committee decided that his confession is not voluntary, therefore his conviction is illegal. But the Singarasa went to the Supreme Court to get enforced the decision of the Human Rights Committee of United Nations, but the Supreme Court said that no, Sri Lanka is not bound by the decision of the Human Rights Committee of the United Nations, and the Supreme Court did not enforce that decision. So, it's a black mark as far as the confessions are concerned, Anuradi.
And relating to confessions as well, I wanted to get a little bit of a specific relating to other inadmissible evidence that might have been illegally obtained. But alongside that, I want to ask you relating to the Attorney General's role when it comes to the procedure of a fair criminal trial. Can you please help us understand exactly the role that the Attorney General's Department plays when it comes to ensuring that proper procedure takes place and that they are also upholding that end of the bargain, because of course it's not just the defense attorney that has to represent the Attorney General's Department will have quite a role to play as well.
Yes, Attorney General or the officers of the Attorney General's Department, they play a very important role. The Attorney General is the chief legal officer of the state and the main advisor of the government. So, Attorney General represent government officials in litigations, especially when it comes to a fundamental right case. Attorney General will represent those officers, and Attorney General will give advice to the government institutions when the government institution require the advice of the Attorney General. And when it comes to a criminal case, Attorney General or the State Council always act as a fair person. He or she doesn't want to a conviction. Because whether there is, assuming there is evidence favorable to the accused, so Attorney General always disclose that evidence favorable to the accused. And I would say that it is the Attorney General who decide whether the accused can be indicted or whether there is sufficient evidence against the accused to be indicted. If not, Attorney General can discharge him. So, I would say in most of the cases, I have seen the officers of the Attorney General Department play a very fair play. They don't want to get a conviction at any cost. They are trying to act fairly. So, I am happy about that as a defense lawyer.
And
Anuradhi.
ensuring that there is justice and it's not just a conviction that they're going after.
Exactly, Anuradhi. So, as far as the members of the Attorney General Department is concerned, state councils and senior officers are concerned, I have seen most of them are always trying to play a fair game, because this is not a, you don't need to sustain a conviction at any cost if there is evidence favorable to the accused in most of the time. Even if the counsel of the accused doesn't know about that evidence, the state counsel will inform the court that there is evidence against the accused, but in the meantime, there is a piece of evidence which is favorable to the accused, and the Attorney General will present such evidence to the court.
Yes, and I want to get into the international context as well. You mentioned it previously, but specifically relating to the bail system and its operation in Sri Lanka also, and maybe what we can expect to see when it comes to the moving forward of this legal landscape, the reforms and amendments that we might be able to see, and with your experience as well, sir, what exactly you think are the main lapses in this kind of setting for Sri Lanka's criminal procedures. But before we get into any of those specifics, let's take a very short commercial break. You're watching Law, Land and Liberty on Other Derana News Channel. We'll be right back after this. Stay tuned.
Adla. So this is a future-based question. What cap EE is expect as moving forward?
Welcome back to Law, Land and Liberty on Other Derana News Channel. We're in our final segment in conversation with Mr. Darshana Kuruppu, attorney at law. So thank you so much for the previous two segments. Unfortunately, we are running out of time, even though there's a lot more that we can touch on when it comes to this legal area. I feel like we were able to cover most of the basics and understanding the fundamental aspects of a fair trial in criminal procedure setting. Specifically relating to one important aspect of a criminal procedure, which is bail, specifically when it comes to the effectiveness of the bail system that we have operating in Sri Lanka. Can you tell us, with your experience, if the system that we have in place when it comes to the issuance of bail is actually conducive to a fair trial environment? Do you think that there are lapses in that area? What kind of encounters have you had practically as well with your experience?
Yes, Anuradhi, actually, as far as the Bail Act number 30 of 1997 is concerned, which was introduced in order to make sure that bail is the rule, jail is the exception. That is because to protect the presumption of innocence. As I earlier said, every accused person is having this right to a presumption of innocence. So, if you are kept in remand custody until the trial is concluded, I would say that right would be violated. So, the bail is, section 2 of the Bail Act says, granting bail is the rule. In order to refuse bail, there should be exceptions. The learned magistrate, if it is a bailable offence, if the magistrate is deciding to remand or the reject or refuse the bail, magistrate has to give reasons as to why she or he does not grant bail to the accused. That is in order to protect the civil liberty of the suspect, because you are not a convicted prisoner. Presumption of innocence is still there, operates in favor of you. So, but unfortunately, I have seen in many cases, even by the Supreme Court also, there are several judgments. Recently, although the Supreme Court delivered a judgment that bail cannot be rejected on the basis of the investigation is not completed, or there are some other suspects to be arrested. That should not be a reason to reject bail. So, but unfortunately, I have seen there are instances where there is no prima facie evidence against the suspect, still the suspects are kept in remand custody. And sometimes bail conditions are very strict, very heavy. There is an Indian Supreme Court judgment which says the court should impose bail condition having considered the circumstances of the suspect. Assuming beggar is arrested for stealing something. And if you impose heavy bail conditions to furnish a government or executive officer or some of rupees 100,000, so he will or she will not be able to furnish. If so, he will or she will have to remain in prison custody until the case is heard. So I have seen there are instances some judges impose very strict conditions and harsh conditions that the suspects cannot furnish the bail conditions. There are several suspects in remand prisons. Their remand prisons bail had been granted, but unfortunately they can't furnish the bail. So we'll have to consider when it comes to a country like ours, there are many suspects, they are below the poverty line. So if you impose a cash bail, judge has to mindful to the economic background of the suspect. And I would say, since bail is a right, judges should always impose conditions that the suspects can furnish. So they can come out. Bail is there to make sure that suspect would come to the court on the next given date. So there are, but unfortunately there are certain acts. Now as far as if a suspect is arrested for the possession of heroin, if the quantity is about 10 grams, the bail jurisdiction is with the Court of Appeal. Assuming you are living in Trincomalee, so you'll have to, all the way you'll have to come to the Court of Appeal and retain a lawyer to get bail. So I have seen there are several suspects are languishing in jail just because that they can't afford a lawyer here in Colombo, or even they can't afford the bus fare in order to seek legal advice from the Legal Aid Commission. So that is a very pathetic situation of affairs. I would say I can still remember when Professor G.L. Pires introduced the Bail Act. He categorically said in the Parliament he has visited almost every prison in Sri Lanka. Our prisons are overcrowded, conditions are, I would say, pathetic. Even if you are a suspect, you will not be able, because you are presumed to be innocent, but if you are put in jail, you will not be able to have a better life there. So that means you are punished even before court decides whether you are guilty or not.
Exactly. And there's this concern as well, as you mentioned, sir, now with the current state of affairs that we have as well, there's a lot of areas or room for reforms and improvements that we can expect to see moving forward. With your experience and with your understanding of how you have approached this legal landscape, specifically relating to how sensitive criminal matters can be when it comes to the trial proceedings as well, where do you see the fastest addressable lapses in our system, especially if we are going to talk about amendments and reforms moving forward? Where do you think we should be putting our attention to first and foremost when it comes to helping to ensure that the system remains balanced when it comes to justice being delivered in a criminal trial context?
Anuradhi, I have seen there are many accused and suspects are being detained in our prisons who were arrested under the Prevention of Terrorism Temporary Act. That temporary act was introduced in 1979. It was a temporary act, but it is still in force. I would say that is a draconian law which should be amended. There should be an act in order to prevent or in order to address the issue of terrorism. But unfortunately, I would say this is the most misused act of Sri Lanka. There are many innocent Tamil people behind our bars who were arrested under this act, I would say the actually not only lawyers, even the civil society, they have been demanding an amendment or repeal of this act and introduction of a new act. I would also agree with them. I would say that this draconian law should be changed, and there are certain other lapses actually. As I earlier said, justice delayed is justice denied, and in the meantime, justice hurried is justice buried. There should be a balance, and that is why court always grant sufficient time for the accused to get ready for the trial. So there should be, because there is no mathematical formula can be introduced, but there should be certain guidelines should be introduced as to how a trial should be conducted, and trial should be actually assuming if you are charged for committing a crime, you at least within reasonable time period, assuming within 5 years your trial should be concluded. So it is up to the prosecution and the defense to make sure that you will assist the court to conclude your trial. And there are certain reforms are required in order to address the issues that we are currently facing, Anuradhi.
And finally, sir, a question to end us off specifically, just to ensure that we are able to touch on just very briefly the other side, the flip side of the coin, victims and witnesses. Before we leave this discussion off, I want to ask you, in your opinion, if you think the rights that are presently available are appropriately balanced when it comes to protections that are awarded not just to the suspect but also to the victims and witnesses. In your opinion, do you believe that we have a balanced playing field right now? What is it looking like, sir?
Exactly, because in 2023, the Parliament introduced victims and witnesses. Now the victim and witnesses are now protected under Assistance and Protection of Victims of Crime and Witnesses Act number 10 of 2023. This law was introduced because there are serious allegations that witnesses and victims, they don't come before court because of they are threatened or they are intimidated by the accused, and in most of the cases I have seen witnesses have left the country because in order to make sure that their life will not be in danger. And victims also, sometimes victim is the witness. Assuming if you are a victim of a rape case, you are the victim and you are the main witness. You are the star witness for the prosecution. And if you are intimidated or if you are harassed, you will not come before court in order to give evidence. That is why this act was introduced, and now there is authority which was established under this act. And this authority, I would say, I am very happy to say, this authority had taken lot of steps to make sure that witnesses and victims of crimes are safeguarded and they are protected and they can come before courts and give evidence. And there are a lot of new mechanisms have been introduced in order to protect the victim and witnesses. I would say this law is more than sufficient to address the issues that victim and witnesses faced earlier, Anuradhi.
That is unfortunately the perfect moment for us to unfortunately have to end off on this discussion. We have mostly a balanced landscape when it comes to the protection of witnesses, suspects and victims as well, and that is what is important at the end of the day, to ensure that justice prevails and a fair trial is possible for all and any citizen of Sri Lanka. Thank you very much once again, sir, for coming to the studio to explain this very vast concept to us. I feel like our viewers would have gotten a foundational understanding of what rights are awarded to them regardless of the side on the stand on which they face. Thank you so much.
Thank you, Anuradhi.
All right, well, we'll leave you tonight with the words of Jean Garamendi. Anyone can be falsely accused of a crime. Everyone accused of a crime deserves a fair trial. That's all we have for you tonight. You can always rewatch by catching us on our YouTube page, and we value your opinion, so please share your thoughts and feedback with us through email at feedback.adncenglish@derana.lk or via WhatsApp at 076 805 7933. Thank you very much for watching. Have a great night.